All right, let's just think about this for a second. When you're facing serious charges, your defense attorney, that's your lifeline, right? You're literally putting your freedom in their hands. But what we're going to look at today is a case where that trust was pushed to the absolute limit. So that's the big question, isn't it? What does happen when the one person who's supposed to be fighting for you just isn't? This question is central to the story of Kelly Lynch. And believe me, her case shows a breakdown in the system that's so deep, it makes you wonder about the whole idea of having a proper defense. So let's dive in. The first chapter of this story is what the case file actually calls the phantom defense. And that name is perfect. Because this isn't about one little slip-up. We're talking about a long, drawn-out period where it felt like the case just vanished into thin air. Okay, just look at this timeline. It's pretty staggering. We're talking about a full year passing, from the summer of 2022 to the summer of 2023. For Kelly Lynch, that's an entire year of her life, just hanging in the balance, waiting for a defense that was basically going nowhere. So let's break down exactly how this happened. Well, it all started with something called a motion for continuance. It's basically a legal way to ask for a delay. And her attorney, a Mr. Mills, filed the first one way back in July 2022, saying he had conflicts with other cases. Okay, fair enough, that happens. But this wasn't a one-and-done thing. It happened again and again. And the result? All progress just froze. No talking to witnesses, no preparing the case, absolutely nothing. Just waiting. Then, fast forward to January 2023. After months of basically radio silence, there's finally a sign of life. A text message from Mills himself saying, and I quote, "We are coordinating the depots as we speak." Now, you can imagine, for the client's team, this must have felt like a huge relief. Finally, it sounds like the wheels are turning. Except, they weren't. The depositions were scheduled for March 29th, and they just didn't happen. That text message, that little bit of hope, it turned out to be completely empty. The phantom defense was still in full effect, but now the court was really starting to pay attention. And this is where things really hit a breaking point. These delays and all these failures, they weren't just a private frustration anymore. This was all about to blow up in open court, and the consequences were going to be serious. Get this, on April 13th, 2023, there's a really important hearing, and the main defense attorney, Mr. Mills, he doesn't even show up. He sends a substitute lawyer in his place. Just picture that. The case has been dragging for a year and a half, and your own lawyer doesn't even come to court. So this substitute lawyer has to stand up and admit something pretty incredible. They hadn't even managed to serve the subpoenas to the witnesses. And why not? Because they were still using the wrong address for a key witness, an address they'd been told was wrong almost a full year before. It's just unbelievable. And you can bet the prosecutor was having none of it. Assistant State Attorney Walsh just lays it out. This case is a year and a half old. You can just feel the frustration in that statement, right? It's right there in the record. This had gone way beyond a simple delay. It was starting to make the whole process look like a joke. And that was the final straw for the judge. He'd had enough. He denied any more delays and set a mandatory hearing for the very next week. The message was loud and clear. The time for excuses was officially over. So at that mandatory hearing, with nowhere left to hide, Attorney Mills finally shows up. And when he's confronted about all the discovery problems, he says, point blank, "Yeah, I'll take fault for that." A direct admission of responsibility right there in the official court transcript. Okay, so that admission, combined with all that pressure from the court, it pushes everyone straight into plea negotiations. But look, this wasn't your typical plea deal where you're haggling over different outcomes. No, the stakes here were incredibly specific and unbelievably high. Now, to really get what happens next, we have to talk about a crucial legal term, mandatory minimum sentence. It's exactly what it sounds like. If you plead to a charge that has one, the judge's hands are tied. They have to sentence you to prison for at least that amount of time. No ifs, ands, or buts. Probation, it's just not an option. And the prosecutor, ASA Walsh, made this brutally clear during the negotiations. He didn't just mention the mandatory minimum in passing, he spelled it out for the entire defense team. He literally said, so she would be going to prison. There was absolutely zero room for misunderstanding among the lawyers in that room. A plea meant prison. Full stop.
So on June 23rd, it's time for the formal plea hearing. Kelly Lynch officially enters her plea, which is nolo contendere, or no contest. Now, for sentencing purposes, that's pretty much the same as a guilty plea. This was it, the moment it all became official and legally binding. And just to make sure there wasn't a shred of doubt, the prosecutor, Walsh, he jumps in again. He makes sure that the judge, on the record, directly tells Ms. Lynch about the mandatory minimums. 5 years for one count, 3 years for the other. I mean, the court record is airtight on this. You'd think everyone in that room understood that prison was mandatory, or so it seemed. But what happens right after that hearing? Honestly, it might be the most shocking part of this whole story. It reveals this huge, devastating gap between what was said out loud in a court of law and what the client actually understood about what was going to happen to her.
It's like two completely different realities were happening at the same time. In one reality, you've got the lawyers and the judge who all know this plea means mandatory prison time. But in the other reality, Kelly Lynch walks out of that courtroom thinking that probation is still on the table. This isn't a tiny mix-up. This is a catastrophic failure of communication.
And we know this for a fact. Here's the proof. It's a text message sent from the client's team to Attorney Mills right after the plea hearing. It talks about sentencing scores and then asks flat out about probation. This text is the smoking gun. It proves that at the exact moment her fate was sealed, her own team still thought she might not go to prison. So, faced with this critical, documented misunderstanding from his own client, a direct question about her future, what was Attorney Mills's response? Nothing. Just silence. He never replied to the text.
And that just leaves us with this one giant question, doesn't it? When it comes to a plea bargain, whose job is it to make absolutely sure the defendant understands what's happening? Is it the prosecutor, the judge, or does that final, ultimate responsibility fall on the defense attorney, the one person who is supposed to be in your corner? This case, well, it doesn't give us any easy answers, but it sure forces us to ask the question,